As we talked about last night, under the New York Convention, the arbitration agreement itself is considered presumptively valid. What that means is, if the party that wants to go to arbitration, that is, the party who does not want to go to court, what that party needs to do is just present an agreement that on its face looks valid. We'll talk about the standard of proof, but for now, it's enough to know that what it means is if A wants to go to arbitration and B wants to go to court, a dispute about the validity of the arbitration agreement never arises when both parties want to do the same thing. The only time that a dispute arises about the validity of the arbitration agreement is when the parties have different objectives, which is one party wants to go to arbitration, the other party wants to go to litigation or court. It's only under those circumstances that you have a dispute about the arbitration agreement, right? Next class, we're going to talk about, in great detail, we're going to talk about the separability of the arbitration agreement in the underlying agreement. No two parties enter into an arbitration agreement unless there is some underlying agreement. You don't agree to arbitrate unless you have something else to talk about, right? Something else to arbitrate about. So it's always, arbitration agreements are always a part of another contract. This is called the underlying contract or agreement, and this is called the arbitration agreement. As I said last time, it's possible that you may have this signed in 1994, and then a dispute arises. Now you sign another agreement, an arbitration agreement, that says we shall arbitrate disputes arising out of a contract that was signed back in 1994. This exists. But in many cases, an arbitration agreement is an integral part of one underlying contract. This contract could be about anything, about the building of this facility. If you look at the building of the contract for the building of this facility, I haven't seen it. Chances are that there might be an arbitration agreement. It says the builder and the owner and the architect, whoever is involved, may enter into a contract, and somewhere in that contract they say, if a dispute arises, instead of going to court, we will arbitrate. So when we say those kinds of arbitration agreements are presumptively valid, all we're saying is the party who wants to go to court has the burden of showing why that agreement is invalid. In other words, there is a burden shifting scheme, right? The party that shows, oh, there is Article 25 of this agreement says we shall arbitrate. That is presumptively valid. That means it's the other party, the party who is arguing that the arbitration agreement is invalid, that carries the burden of showing that the agreement is invalid. So that is what it means. It is presumptively valid. So today what we're going to do is talk about presumptive validity in great detail, and we have 4 cases to demonstrate what this notion stands for. But I hope you had access to the reading assignment today. And if you look at the very first page, it gives you a very good outline of what we're going to be doing in the next several classes. The first is talk about presumptive validity. That's what we're going to be doing today. Next class, we're going to talk about the separability presumption. Separability means these are 2 different contracts, okay, potentially subject to 2 different laws, potentially subject to two different or more decision makers. So the arbitration contract itself is a separate contract with its own applicable law, with its own decision maker and all those things. That's what we're going to be talking about next class. It's an extremely important notion. And the third is about competence. Competence, and I'll introduce you very briefly in anticipation of what we're going to be talking about next class. The class after the next one. Consider the situation, A and B. And as I said, A is the guy who wants to go to court. And B is the guy who wants to go to arbitration. And this is the contract that binds them. The contract has two sections. These are designations. We can call them X and Y. Presumptively separate. X is about billing contract. Y is the contract that says we will arbitrate this matter, we're not going to go to court. The principle of competence talks about who decides whether Y, which is the arbitration agreement, is valid or not. Because that decision is very important. It means whether the case about X will be arbitrated or will stay in court. So let's demonstrate further. A is the guy who wants to go to court, right? He initiates a legal action in court. What do you expect B to say to this court? B is the guy who wants to go to arbitration. Exactly. B will appear before this court and submit some motion or whatever it is, telling the court that because there is an arbitration agreement between us, this court lacks jurisdiction, cannot adjudicate this case, and it must compel arbitration. It must send it to the arbitral tribunal. To determine, listen to this, to determine whether or not the court must send the case to arbitration, somebody, whether the court or this arbitral tribunal, must decide whether or not the arbitration agreement is valid. Right? If the arbitration agreement is not valid, what happens? The court will adjudicate the controversy, right? And if it is valid, the court will send it off to the arbitrators. Now, here's the competence question. The competence question is who, the court or the arbitral tribunal, that must first decide whether or not the arbitration agreement is valid. So that is the third class that we will be exploring. It's an important step. So these are the topics under this chapter. Okay, that's the outline that he gave you. The textbook author very, very well outlined it here on page 177. The fourth thing that we're going to be studying is the choice of law. As I said, these are two separate agreements. It is possible that the law of country A would apply to this one, and the law of country B could apply to this one, or the vice versa, right? Or multiple laws could apply. The first thing that you would look at is what law the parties have designated to govern the arbitration contract as well as the underlying contract. The problem arises when the parties have not said anything. Then who decides what law governs and why? So that is what we'll be studying. fourth class after we study the other things that I just described. Okay? So that is the outline. Now, presumptive validity. What do you understand by presumption in law? What is presumption? Raise your hands, whoever wants to tell me what a presumption is. Yes?
Presumption is we consider something to be true, and the burden shifts to another side, to the side.
Exactly. Absolutely right. That's what it means. Presumption, we consider something to be true. And that shifts the burden to the other party to show the contrary. And as I said earlier, that is what the New York Convention provides. Now, I've asked you to bring a copy of the New York Convention, right? And I hope that you've all brought a copy with you. Now, we're going to read the essential section that talks about presumption together, because this is absolutely essential. Before we do that, I want you to take a look at the structure of the New York Convention. We're going to be studying this convention in detail. Okay? I want you to take a look at the structure of this convention. It's very brief, but each provision has given rise to immense controversy. So we'll consider that throughout this quarter. Now, who wants to read Article 1 for us? Article 1:1. Because that is the starting point for this convention. So the New York Convention has, I think currently has 156 states parties. That means almost every state in the world is a member of the New York Convention. It's the most successful instrument of international instrument in the economic arena, particularly in commercial interactions. So if you look at Article 1, the part that I want to emphasize is this. This convention shall apply to the recognition and enforcement of powers or awards made in the territory of a state other than the state where the recognition and enforcement of such awards are sought. What do you understand by that? We're talking about awards, right? We'll come to agreements. Awards. Here, based on your reading of that section, State A, State B. If the award is made in State A and is supposed to be implemented or enforced in State A, does the New York Convention apply? No. It does not, because it says other than State B. So, if the award is made in State A and it's supposed to be enforced in State B, the New York Convention applies. That's its only purpose. Because you don't need a convention to implement an award that's made in your own territory. So that is the first thing. And if you look at subarticle 3, it talks about reservations. We'll study that. Don't worry about it now. Now, what we need to worry about today is Article 2. And I'll read Article 2, the relevant parts for you. Article 2, number 1 says, each contracting state shall recognize an award in writing under which the parties undertake to submit to arbitration all or any differences which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not, concerning a subject matter capable of being settlement by arbitration. And then second, it talks about the term agreement in writing. Could be anything about signed copies, exchange of letters and telegrams. Now, email has been included into by judicial interpretation. We'll talk about that. For purpose of today, the most important one is number 3. Okay? The court of a contracting state, when seized of an action in a matter in respect of which the parties have made an agreement within the meaning of this article, shall, at the request of one of the parties, refer the parties to arbitration unless it finds that the said agreement is null and void, inoperative, or incapable of being performed. So, when I say the source of the presumptive validity of arbitration agreements is the New York Convention, you do understand what is meant by that, right? So, the presumption now we talked about, if you present a copy of an arbitration agreement, it's presumptively valid. What does the other party need to do or to prove that it is not valid? We talked about the burden shifting scheme, right? Once you present a copy of an agreement, the other party has the burden of showing what? All three things, right? Or one of those three things needs to be demonstrated. Now, I assume that you've taken contract law, right? Tell me, raise your hands and tell me, grounds of invalidity of contract under the contract law that you've studied. Raise your hands, yes.
Mutual assent, absence of mutual assent.
Absence of mutual assent.
The invalidity of the contract.
Yeah, invalidity of the contract.
Yes.
But absence of mutual assent is broad. Can you be a little bit more specific? What makes the lack of assent?
Mistake.
Mistake, exactly. What else?
Dues.
Duress.
Undue influence.
Undue influence. Unconscionability.
Public policy.
Public policy, if it is together. So those are the kinds of things that make contracts invalid. Do you see those here? The New York Convention does not say anything like that. It says incapable of being performed, null and void, inoperative. Right? So that is left for judicial interpretation by member states. So we'll see what is meant by those terminologies in applying the New York Convention to a set of factual circumstances. Okay, now let's consider the cases. The first case, the premier case, is the French Court of Cassation, 1843. It's a very old case. It's an interesting one. Do you know what a Court of Cassation is? What is the highest court in Canada?
Supreme Court.
It's the Supreme the People's Court, right? In the United States, it's also the Supreme Court. In France, within the Supreme Court, I don't know if you've heard about this, they have what is called the Court of Cassation. Does anyone speak French here? No? Every time that I teach this class, there's usually one or two students who actually speak French. Maybe that's, yes. What does cassation mean? Do you know?
It means to dismiss a case or return the case to the court.
Lower court. Yes, so the Court of Cassation has the jurisdiction to review cases for error of law. Something that is broken, they mend it. That's the idea. So this is the highest court in France. It's a civil law system. Now, what was the most essential issue presented to this court in this case? This is obviously about the validity of the arbitration agreement, right? Raise your hands and tell me what the most important issue presented to this court was. The reason why I wanted you to focus on very specific cases, instead of assigning you a lot of reading, I limited it because these cases tend to be very complicated. So it may not be enough to read it only once. You might have to go through it twice to have a good understanding of what they're talking about. Right? Or maybe let me be slightly specific. When a court, listen to this, when a court is confronted with a particular set of questions, what is the first thing that it must do?
Jurisdiction.
Huh?
Jurisdiction.
Yeah, assuming that there is jurisdiction. But when they are asked about a particular question, have you taken legal writing? Legal writing. Issue, right? Issue, and then what? Rule, and then they apply the rules to the set of facts. Here, in this case, were they able to successfully identify the applicable law? And was there any confusion about it? There was some confusion about it, right? Which section, what part of the law that they must apply? There was some confusion about that, but they decided somewhere, they said, this is the law that we're going to be applying. What was the confusion about the applicable rule? If you look at the first paragraph, the third paragraph, it starts with whereas Article 332 of the Commercial Code granting parties the right to submit their dispute to arbitration. And then you keep reading, and there is Article 663 of Commercial as subject to specific legislation whose rules could not be extended by the judge without obviously constituting an abuse of judicial power. Purely non-commercial transaction for the issuing party. What they're doing there is excluded. It doesn't fall under this, right? This case does not fall under this provision. They go on doing the same thing about other provisions of the law, and then they find the law to apply. And the law that they applied says something about arbitration in this particular case. So what does that law that they say, okay, here is the law that is appropriate for this case. It's not insurance, it's not this, it's not that. And what does that law tell them about the validity of the arbitration agreement? And for that law, for an arbitration agreement to be valid, what must happen first? Yes?
So in Article 1006, the law said that the arbitration agreement must state the subject of the dispute and the names of the arbitrator.
Exactly. So they finally found a law, and the law specifically says that the subject matter has to be identified and the arbitrators must be identified. See? If the arbitrators from the very beginning are not identified, what happens to the arbitration agreement? Invalid. So where's the presumption then?
Presumptive invalidity.
That is what it sounds like, right? In this case, presumptive invalidity, unless this predates the New York Convention. This is 1843, right? It predates, but even then, imagine what happened in this case. There was this guy who wanted to go to arbitration, right? And there's this other guy who didn't want to go to arbitration. They found themselves before the highest court in France. The reason is the guy who wanted to go to arbitration said, look, we've signed an arbitration agreement, although we have not named the arbitrators, it is still valid. But the court's saying that, wait a minute, an arbitration agreement is just like any agreement. We must first find the applicable law. And if the applicable law has particular specifications, and the arbitration agreement fails to meet those requirements, then it's not valid. In this particular case, the law required you to name the arbitrators for it to be valid. Because you failed to do so, the arbitration agreement is not valid. Right? Now, the court also talks about the policy reason why the law requires naming of arbitrators at the time of contract. What is that policy reason? Why would the law require the parties to name arbitrators to be valid? Why? There is an obvious reason and it's written in there. You have a copy of my book, don't you?
Yes.
And I say somewhere I have a note. you benefit from that. Did they fix your problems? I heard that the online problem has been fixed, right? For the textbook. So that means you're not going to get my notes. So you just download it from online, through our website. But what is the policy reason? Why? Why does the court need the parties to agree beforehand about the arbitrators? You have to say Mr. X, Mr. Y, Mr. Z. If you fail to say that, the arbitration agreement is not valid. Exactly. It's to protect them against their own ignorance. Right? This is an insurance company making people do what? If the arbitration had occurred, where would it have occurred? What was the place of arbitration in this case? Huh? Where? Where was it supposed to happen? Where was the arbitration supposed to happen? Paris. It's supposed to happen in Paris. There's this insurance company selling insurance policies across France. And they wanted these poor guys to come to France to arbitrate. What do? They end up not coming. They're poor. This big insurance company. So the law wanted them to say, okay, if you are contracting to arbitrate in Paris, you may as well identify the people before whom you will be appearing. Because what are they suspecting? Because what they're suspecting is these big insurance companies, they have their own arbitrators, they nominate them over and over again, they always ruin their fate. So it's in a way protecting the consumers. That debate still exists. It is current. When you buy an airplane ticket or a shipping cruise ticket, do you know that it usually contains an arbitration agreement? Do you? You don't even know. Because it's hidden somewhere. Have you, in your civil procedure class, have you studied the Carnival Cruise case? That's what happened, right? You buy a ticket, you have no idea that you're actually giving up your judicial remedy. Because by buying, you're agreeing to an arbitration agreement. What happens? For the big companies, if your phone company charges you 12 RMB unlawfully every month, what are the chances that you're going to sue them in court or go to arbitration against them? Almost zero. You don't go to court for 12 RMB because it's just too small. For the phone companies, you know what they do? They actually charge 1 billion people $12 every month. What kind of money they get? Enormous. Right? If they actually succeed in having everyone agree to an arbitration agreement. In China, I know class action suits are not permitted, but in the United States, what the phone companies, insurance companies, others do is they have you sign an arbitration agreement so that you don't commence a class action lawsuit against them. Because if 100 million people get together and launch a legal action in court against these companies, the companies could get bankrupted. There's damages, there's punitive damages and all those. Because of that, every time that you sign a phone contract, there's something hidden in the back, very fine print that says arbitration. That is basically to say you can't have a report. So this is more or less something like that. And the French court was actually thinking of protecting the customers who buy insurance policies from these remote areas. But in any case, that is very outdated. No court these days would invalidate an otherwise valid arbitration contract because of lack of naming the specific arbitrators. So this is 1843. Okay? Let's proceed. When I assign you readings, sometimes you see a small caption like this, and it could refer you back to another page number. Ignore those, usually. I don't expect you to go back and read the same case from other pages. So when I assign you a range of cases, just concentrate on the text that is in there. You don't have to cross-refer and go back and forth. Okay? And I'd like to refer you to the Kansas law on validity, page 180. It's at the very top of 180. Kansas code is more or less the same as the Federal Arbitration Act, FAA. You will see a reference to FAA throughout your textbook because it's written by an American author. FAA is the American Arbitration Act. The Chinese Arbitration Act, I'm familiar with it, has more or less the same kind of approach because it's based on the New York Convention. The differences are not significant. But under the FAA, the rule that you see here is more or less the same. It's about invalidity of contract, right? Let's read it together. 180 at the very top, Kansas Code 2010. A written agreement to submit any existing controversy to arbitration arising between the parties bound by the terms of the writing is valid, enforceable, and irrevocable, save upon such grounds as exists a law in an equity for the revocation of any contract. Is this provision consistent with Article 2.3 of the New York Convention that we just looked at? Remember, under the New York Convention, an arbitration contract is presumptively valid unless it's null and void, inoperative, or incapable of being performed. Under Kansas law, an arbitration agreement is presumptively valid, save upon such grounds as exists a law or an equity for the revocation of any contract. Are they saying the same thing in a different language? Or is it broader than the New York Convention? Or is it narrower of the New York Convention? Okay, there is no resolution to this problem, and there's no reason why you should know the answer to that question, because that's all it says, right? That's all it says. Now, the FAA has two sections. One is for domestic arbitration, another one is for international arbitration. The domestic arbitration section says exactly like this. Those are the grounds of invalidity as they exist under law or equity. In the United States, in the old days, the distinction is no longer very meaningful. There were grounds in law and in equity. Now they have sort of merged. When you talk about equitable relief, it means a completely different thing. Do you know what equitable relief But in the old days, there are grounds in law, grounds in equity. So section 1 of the FAA is about domestic arbitration, and those are the grounds of invalidity. Section 2 is the incorporation of the New York Convention, and the grounds that you have are exactly identical as the New York Convention. Null and void, not pertaining, capable of being performed. By judicial interpretation, these things tend to merge. We will see about how those actually function. Now, let's go to the second case about levy ceramity. Who wants to give us some of the facts of this case? Or at least tell me who wants to go to arbitration and who wants to go to court. One party is from Puerto Rico, the United States territory, and the other party is an Italian party. Which party wanted to go to arbitration? The Italian party. Why? Why do they want to go to arbitration?
The tribunal is in Italy.
Yes, it is in Italy, right? And how were the members of the tribunal, who was supposed to be the arbitrator under the agreement? Who was supposed to be the arbitrator?
President of the tribunal, Modena.
Yes, somewhere in France, in Italy, right? So you can imagine the little guy, the Puerto Rican dealership. This is very common. This is very common, right? You have a big car manufacturing company or a big manufacturing ceramics. They distribute in 100 different countries. What do? They hire the small guys to distribute. Sometimes they give them exclusive distributorship. Sometimes they don't give them. Sometimes they abuse them. These are the little guys and these are the big guys. This Italian company, I presume, would be a big guy who gave a contract to this little distributor in Puerto Rico. And in that contract, they had him sign an arbitration agreement. In the arbitration agreement, not surprisingly, wants to take this Puerto Rican dealership to arbitration in Italy. And interestingly, the guy who was supposed to arbitrate is also Italian. No wonder then that the Puerto Ricans do not like the state. What happened? What were they complaining about?
Public order.
Yes, but what did they do to them? This big company. What did they do to the little distributorship in Puerto Rico? What were they complaining about substantively? I'm not talking about the arbitration agreement. Substantively, what was the cause of action? What was the injury they suffered? What were they complaining about? Raise your hands, please. One.
Breach
Yes.
of contract.
Huh?
Breach of contract. Unjustly termination of contract.
Exactly. They just terminated them without cause and they abused them, right? It's a breach of contract claim they have against them. So, where did they go first? The Puerto Rican company. They initiated a lawsuit.
Yes.
Where? State court or federal court? State court.
State court. District court.
Right?
Yes.
In Puerto Rico. Their own court.
US 2.
Well,
42.
from your civil procedure class, what was the basis of federal jurisdiction for the Italian company to, what did they do? What did the Italian company do?
Diversity jurisdiction.
Exactly. So they actually moved it from state court to federal court. Diversity jurisdiction. Let me ask you a more difficult question. Diversity is obvious because they are Italian and these guys are Puerto Rican. No problem. There is a federal court in Puerto Rico. There was another basis for federal jurisdiction, and that is what we're talking about in this case. What was that basis for federal jurisdiction? Federal question arose out of federal law, right? What federal law?
Constitution, statute, and treaty.
So what was the statute in this case?
Dealers Act.
Dealers Act.
Huh?
Dealers
Dealers
Act.
Act.
No, that was state law. The Dealers Act is state law.
LPO.
Because the answer to this question actually is based on what law governed.
FAA.
FAA.
The Federal Arbitration Act was supposed to govern the relationship between the Puerto Rican dealership and the Italian ceramic company. So if you were the lawyer hired by the Italian company, and then you get summons, a service of process that says these dealerships in Puerto Rico, they have actually sued you in district court in Puerto Rico. You're sitting in your office somewhere in Milan and you're thinking about strategy. Give me the contract, I want to look at it. You see the contract, it says arbitration under what rules in Milan or whatever it is. It's then that you start thinking about, first, we should move it to federal court. Obviously, the federal courts are supposed to be less biased. And secondly, if we move it to federal court, the law of decision, the rule of decision would differ from the Dealers Act of Puerto Rico that obviously you're not going to like if you are representing the Italian company and you want to get it under the FAA, which is federal law, because under federal law, the grounds of invalidity, especially under Section 2, what they talk about the New York Convention, this is 1982, this is after the New York Convention, this is after the New York Convention has become part of the United States law. The grounds of invalidity are now limited to the three things: null and void, inoperative, incapable of being performed. Nothing else. What does that do? It actually completely excludes the cause of action arising out of state law. That's the dealership. Because the dealership law, the Puerto Rican dealership law would have actually completely killed this arbitration treaty. Why? What does it say? It says what?
Conditions, contractual law, morals, or public policy will be involved.
That is what it says, but it actually specifically, more specifically addresses this exact situation. It is pro little guys and anti big guys. It talks about public policy. You cannot terminate dealership unless you have what?
Good reasons.
Exactly. Good cause. See? You cannot terminate it unless you have good cause. The Italian company probably just dismissed them, didn't care about them. And termination without cause is public policy. It's enshrined, it's included in the law itself, it's written in there. So if the Puerto Rican law applies, the arbitration agreement might be found invalid. If the FAA applies, however, the arbitration agreement may be found valid. And if it is found to be valid, what is the result? Exactly. Go to arbitration and see what happens. So the Puerto Rican guys, obviously, were not thrilled about going to Italy to arbitrate this matter. Now, in interpreting the language of the New York Convention about null and void, inoperative, incapable of being performed, this court relies on another court's decision and they give it a specific name. Null and void, inoperative, incapable of being performed means three other things. What are those three other things? And those should be familiar to you from your contract class.
fraud, mistake, duress.
Exactly. So before activity, not Ricky. Fraud, mistake, duress, and waiver. That's it. The meaning of the term null and void, inoperative, incapable of being performed under the Neo Convention, under U.S. law, means fraud, mistake, duress, and waiver. So if you want to get out of an arbitration agreement under United States law, under the FAA, you must prove the existence of at least one of these grounds of invalidity. So when I say arbitration agreements are presumptively valid, it means that the other party has the burden of showing at least one of those grounds to get out of the arbitration. If the arbitration agreement is found valid, the arbitration continues. The court must compel arbitration. The court shall refer the parties to arbitration. If the arbitration contract is considered invalid because there is no consent to arbitrate, the court must continue to adjudicate the controversy. That's what it means. When I assign cases, I want you to pay closer attention. You should read all of them carefully, but you should pay closer attention to the cases from the Circuit Courts of Appeals of the United States, Supreme Court of the United States, and the House of Lords of the United Kingdom. It's because, not because they are in any way superior, but they are easier to follow, and the authorship of the textbook has its own bias in favor of those, and they are better reproduced, better edited, and easier to understand. And they are better representations of modern interpretation of these laws. The French cases tend to be complicated, partly because of the translation from French to English. You should pay attention to those and all others, but the Circuit Court of Appeals, Supreme Court, UK House of Lords cases, I think you should pay more attention to them. So this is, I think, the First Circuit Court of Appeals 1982. Okay, so we have two more cases to cover today. Let's take a brief break and come back and complete. Okay, 10 minutes.